Can I file bankruptcy if my student loans are in default? Have you found yourself wondering if bankruptcy is an option for your student loans that are in default? You are not alone. Many people face this tough situation and want to know their options. The good news is that yes, you can file for bankruptcy even if your student loans are in default. However, there are some important details to keep in mind. Filing for bankruptcy can provide immediate relief from collection actions. This includes stopping wage garnishments and halting tax refund offsets. Once you file, an automatic stay goes into effect, which pauses most collection efforts. But here's the catch. Simply filing for bankruptcy does not automatically erase your student loan debt, even if it is in default. To potentially discharge your student loans, you will need to file for either Chapter 7 or Chapter 13 bankruptcy. Chapter 7 involves liquidating non-exempt assets to pay off creditors. On the other hand, Chapter 13 allows you to reorganize your debts into a repayment plan that lasts 3 to 5 years. After filing for bankruptcy, you must take an additional step called an adversary proceeding. This is a lawsuit within your bankruptcy case. In this proceeding, you must prove that repaying your student loans would cause you undue hardship. This is a strict standard that courts apply, and it can be quite challenging to meet. What does undue hardship mean? It generally means that repaying your loans would prevent you from maintaining a minimal standard of living for yourself and your dependents. You must also show that this situation is likely to continue for a significant part of the repayment period. Lastly, you need to demonstrate that you have made good faith efforts to repay the loans. If you succeed in this adversary proceeding, the court may discharge some or all of your student loan debt. However, if you do not meet the standard, your loans will remain yours, and you will still need to repay them, even after discharging other debts through bankruptcy. In summary, while having student loans in default does not stop you from filing for bankruptcy, discharging those loans requires a separate legal process that can be quite difficult. Bankruptcy can provide temporary relief from collection actions during this process, but the permanent elimination of student loan debt is rare. Consulting with a bankruptcy attorney who has experience with student loan cases is a smart move to help you navigate this complex process effectively.